Welcome to EPG Pathshala. We are discussing the course on social policy. We are specifically going to discuss at the moment the module on labor standards within social policy. My name is Sohini Sengupta. I am an assistant professor in the School of Social Work at the Tata Institute of Social Sciences. Let us look at the objectives of this module. Through this module, the students will understand the interlinkages between labor laws and legislations and regulation with social policy, and how the notion of social protection, social insurance, welfare entitlements is connected to the nature of work and employment available to the citizens in a country. Specifically, the students will learn about the concept and function of the concept of minimum wage, central labor laws and social protection rule in the context of India, recent reforms in labor laws, and informal sector work. Labor laws can be defined as rules that protect workers, including legally mandated labor standards and social security systems that shape employment relationships. Comprehensive labor standards, including right to organize and set minimum levels for wages and working conditions. These play an important role in poverty reduction and reduce social and economic inequalities. They help to redistribute wealth in society and observe the effects of macroeconomic shock, redress the balance between capital and labor, and improve workers' welfare. Essentially, labor laws or labor guarantee are one of the provisions that welfare states had always created historically. Essentially, it performs, as we have understood, multiple layers of function that not only reduces societal inequality, contributes to poverty reduction, but also helps to reduce risks from macroeconomic shocks for people who are employed and under protection of labor legislation. Historically, labor laws have emerged with the growth of industrial economy and formal sector employments. In low and middle income countries, the presence of large unorganized sector prevents the emergence of labor standards, because even though a formal sector exists in these countries, the labor standards are created, the labor laws usually addresses the rights and entitlements of workers who are employed in the formal sector, but it does not do much to reduce risks of large number of people who would be working in the unorganized sector. Can risks from being employed in the informal sector also be addressed through appropriate labor standards, efficient implementation of laws, and social security intervention by the state? This is one of the questions that is a social policy concern, and that we will try to address by looking at different types of central labor laws that exist in the country. The term sweating is attributed to British economist Sidney Webb, who coined the term in the early 20th century to refer to earnings that were barely sufficient to sustain existence. It was used to describe a situation in which workers worked for extremely low wages that did not support a socially acceptable level of wholesome family life. A related term is sweatshop, which even we are familiar with, associated with long duration of work in unsafe working condition and poverty level wages. Historically, labor laws, trade unions, and emergence of labor standards have checked the growth of sweatshop type of working condition. The logical transition from a discussion on working for long hours for poor wages under unsafe working condition is to come to a key concept called minimum wages. Early proponents of the minimum wages argued that the poor and vulnerable workers, such as women, children, and the unskilled, lacked representation and collective bargaining power, which essentially meant that they had nothing to exchange and that they had nothing to bargain with their employers, which would make the employers give them fair wages. Under these circumstances, it was felt that it is the responsibility of the government to correct the markets and serve as collective bargaining proxy for these workers in order to ensure them a standard of living acceptable to society. What this means is essentially, since the large number of people, vulnerable sections of the population who are likely to work for very low wages in unsafe conditions in the informal sector and also lack bargaining power to demand fair wages, someone needs to step in for them to bargain instead of them. And this is the role that the governments had, and this is the responsibility they had to ensure that even those who lack collective bargaining power actually can avail of fair wages. Public demand for social justice by workers resulted in the emergence of the minimum wages in the late 19th century. In India, the Minimum Wages Act came into being as one of the earliest legislations in the country in 1948. The Act empowers both central and state governments to fix and revise minimum wage rates. Several different types of employments are covered in the schedule to this Act. The schedule is in two parts. Part 2 deals with employment in agriculture. The appropriate governments have notified the list of scheduled employments in Part 1 and 2. So we do have a minimum wage law in our country. National floor level minimum wage. This is a relatively recent concept that has entered into the debate about the minimum wages. Recent changes have led to the creation of something called a national floor level minimum wage. In 1991, the national floor level minimum wage was created on the basis of recommendations of the National Commission on Rural Labor. Despite the NFLMW, which constitutes a non-binding standard, a wide-ranging diversity is present in minimum wage standards in India. The trouble is, as state governments and different state governments as well as the central government can create minimum wages for different types of occupations and in different locations. As a consequence, there exists in our country large number of minimum wages that are associated with different occupations. So there's a huge diversity. The objective of the national floor level minimum wage was to bring a particular standard to bind all these to reduce this diversity and bring in uniformity in creation of a minimum wage law. At the state level, minimum wages are set differently for selected occupation. Some estimates cite more than 1,000 minimum wage rates for different categories of workers in the Indian context. This amount of complexity often makes it difficult to implement the conditions, implement the labor standards that are implicit in the Minimum Wage Act. Benefits of a statutory minimum wage. How does the minimum wage actually provide security to workers? In the context of India, the statutory minimum wage compliance is likely to have a poverty and inequality reduction effect. A large proportion of wage earners in India are poor, low-skilled people in rural and urban areas. Receiving minimum wage would enable these families to move out of poverty. On the other hand, not receiving minimum wages would increase the probability of casual workers to continue to live in poverty. Recently, the Ministry of Labour and Employment requested all the states and union territory governments to ensure that minimum wages for all scheduled employments is not less than the national floor level minimum wage. It is also proposed to amend the Minimum Wages Act 1948 to make the NFLMW statutory. Provided the minimum wage is being implemented, it can have large welfare effects for people working in not only in the formal sector but also in the informal sector. But this is something that remains to be done in the context of our country. Framing and administration. Labor is on the concurrent list in the Indian Constitution, which essentially means that regulatory provisions on the conditions of work are in the domain of both state and central government. Labor laws can be legislated by both state and the center. There are several central labor laws. In general, state governments frame the coverage and implementation rules for the central laws and also pass state-specific labor laws. The state labor departments are responsible for the implementation of central and state labor laws. Laws are enforced through state-level personnel such as labor officers, inspectors at the district level, and labor commissioners heading the institutional structure. Being on the concurrent list, implementing labor standards is a complicated exercise in which a large number of departments and a large number of functionaries and hierarchical levels are involved. Often this makes it difficult to follow through whether people are actually receiving the provisions that are given to them under various different types of state and central laws. Let us now look at some specific labor laws relevant to our present context. Some of these laws are also being reformed and new amendments are being put in place. The Industrial Disputes Act 1947. This law guides the hiring and firing rules of industrial sector. It requires that any company employing more than 100 workers needs to get permission from the government before laying off workers, which is rarely granted. What this essentially means is the Industrial Disputes Act provides people with who have gained employment in certain industries a certain security of work, because it is not easy to fire these workers. In fact, India is supposed to have one of the toughest dismissal laws in the whole world. The Trade Union Act 1926 and the Trade Unions Amendment Act 2001. This law defines trade unions along with their rights and responsibilities and gives them legal status through registration. What this enables workers to do is that they can come together as a group and collectively bargain for improvement in both wages and working conditions and other forms of insurance and benefits with their employers. Other important laws that for creating labor standards, providing minimum wages, as well as creating equality conditions in society are the Equal Remuneration Act 1976. This act is applicable for women workers and provides for the payment of equal wages to men and women workers and for the prevention of discrimination on the ground of sex against women in employment. The Equal Remuneration Act was created in order to reduce the inequality in society, improve women's labor force participation, and also to make employers pay the same amount of wages when the same work is done by male and women employees. The Contract Labor Regulation and Abolition Act 1970. This act is applicable to any establishment where 20 or more workmen are employed as contract labor on any day in the preceding 12-month period. Act contains provision regarding health and welfare of contract workers and wage payment security. The Contract Labor Regulation Act tries to bring within the purview of labor standards even those people who do not work in the formal sector. The idea is that even when one does not have a permanent employment or an employment guarantee for a long period of time, the safe conditions of work as well as equal remunerations and good pay should be provided also to people who are working on contracts. Laws relevant to agricultural workers. Agricultural workers perhaps are a group who are not very well covered by any specific labor law per se. Agricultural workers do not have protective coverage under any specific labor law and constitute the largest among the most vulnerable segment of the unorganized sector. The two labor laws that protect the interests of agricultural workers tangentially include the Minimum Wages Act 1948 and the Plantation Labor Act 1951, which is actually applicable only to plantation workers. Other relevant laws include the Bonded Labor System Abolition Act 1976 and the Child Labor Prohibition and Regulation Act 1986. The Child Labor Prohibition and Regulation Amendment Act 2016 and the Equal Remuneration Act. Agricultural workers often face a large amount of insecurities and instabilities in their earning and seasonality in their livelihood, and creating labor standards for agricultural workers would be really important if we are serious about providing minimum basic social protection to a large chunk of the population in India. Labor law reform. Labor laws in India are considered by some authors to be more suitable to the post-independent period and in need of considerable revision. Recently, the Ministry of Labour has proposed to codify a number of older labor laws in India into 4 main codes. Through this exercise, the labor laws will be compressed into 4 codes, namely industrial relations, social security and safety, health and working condition. The Finance Minister highlighted the above reforms in the present 2017-18 budget. India has very strict dismissal laws. Dismissal laws are deemed to have been strict in India. One of the highlights of the proposed amendment in labor laws is to raise the size of units that can retrench workers without seeking prior permission from the government. Under older labor regulations, in units employing 100 workers could close down or retrench without seeking permission. Once in place, the reformed code on industrial relations would allow units employing 300 workers to do the same. Essentially, these reforms in labor laws have created some amount of insecurity amongst observers who feel that are we by any chance diluting the labor standards that we have in the country? Because that would eventually result in reducing both the income security as well as other parameters that workers today, other benefits that workers today enjoy in terms of safe and secure working conditions, various types of insurance, ability to collectively bargain, and so on. Unorganized and an informal sector is a very, very vast area in the context of India. The latest National Sample Survey Office data show that the labor force in India consists of 483.7 million people. Out of this, 472.8 million are employed and 83% work in the unorganized sector in low income employment. Some examples of unorganized sector workers are rickshaw pullers, street vendors, handloom artisans, fisheries worker, and unskilled home-based worker. This category of about close to 500 million people are not covered by existing labor regulations at all, and they do not have access to any social security and welfare benefits that emerges from their status as members of the labor force. Unorganized sector is also believed to be growing in the current economic context, where a large majority of the work that would be generated in future would be in the unorganized sector. In such a context, what should be the social policy measure that we can create in order to ensure that the unorganized sector workers are not exploited, both in terms of being paid less wages, made to work longer hours, not having access to health care and other insurance, being dismissed when they're not fit to work, not having access to any kind of accident insurance, basically being very, very vulnerable and exposed to all kinds of idiosyncratic as well as covariant shocks, as our social risk management framework would suggest. What in such a situation should be the ideal policy direction towards dealing with large number of people who are going to be working in the unorganized sector? If you look at the NCUS 2007 report, you will have you'll obtain a definition of who actually constitutes the workers in the unorganized sector in the context of our country. In India, the definition of the unorganized sector includes people who work in the unorganized sector as well as enterprises which are self-owned enterprises. So if you look at this diagram, it shows you how the unorganized sector is constituted in the context of our country. So basically, the unorganized sector consists of two categories, the workers as well as informal enterprises. Among the workers are included those who are self-employed, own account workers, unpaid family workers, employers, own account employers, as well as wage workers. The informal enterprises, on the other hand, includes own account enterprises as well as an establishment which has at least one hired wage worker. So informal sector, which is basically what unorganized sector is called in our country, consists of workers as well as informal enterprises. Now the kind of labor standards that are applicable to workers who work in the informal sector is essentially different from the kind of laws that are applicable to informal enterprises. It's important to remember this definition in order to create social protection mechanisms that would be applicable to people who work in this area. There is a close relationship between informal sector work and poverty. Most informal sector workers are impoverished and suffer from a range of social and economic disadvantages. In fact, that is precisely the reason why they're working in the informal sector. The the sources of insecurity, the sources of disadvantage in the informal sector emerges through insecurity of employment. The employment that is provided to people is not guaranteed. It's neither long term, nor it has any, nor is there any guarantee that it will be able to provide people with enough earnings to make them lead, to enable them to lead a decent quality of life. The remuneration may be low, the remuneration may be irregular, which means people will not be having a steady stream of income even after working for long hours. The long duration of work may be taking place in very poor and unsafe working conditions. Recent reports of, for example, the recent reports of fire in the context of our neighboring country Bangladesh, where a large number of people perished while working in sweatshop-like setups in the garment industry, are an example of unsafe working condition. In the context of our country, quite a lot of people work in mining areas, in relatively hazardous tasks, and so in the informal sector, such as collecting coal or practicing artisanal mining. These are in effect highly hazardous occupation which involve working in poor and unsafe conditions. All of these workers are also lacking access to redress in case of any dispute with their employers, because they do not technically fall under any particular labor standards or guarantees. This may result in a forced labor situation and gender and caste-based discrimination and no social security in the event of any mishaps. Historically, a large and persistent informal sector in any country has been associated with high levels of poverty, low productivity, and most governments in the past actually promoted formalization of employment as a policy goal. This is a trend, however, that is not happening at the moment anywhere in the world. If anything, jobs are becoming more insecure and more employment is being generated in the informal economy. A direct consequence of this situation, if we are not to have greater poverty in the society, is to have better social protection mechanisms to protect, to improve the living and working conditions of people who have no choice but to work in the informal sector to lead their lives. Looking at this scenario, the government of India has enacted an act called the Social Security Act 2008. The Unorganized Workers Social Security Act 2008 was enacted by the government of India to provide welfare benefits to a large majority of population who were employed in the unorganized sector. 8 existing welfare schemes, which are meant for below poverty line individuals, were directed to individuals registered as unorganized sector workers. These schemes include National Old Age Pension Scheme, Janani Suraksha Yojana, National Family Benefit Scheme, and National Swasthya Bima Yojana, which is a form of health insurance. The law which emerged from the NCUS report does not address the recommendations or provisions of a universal minimum social security for all informal sector workers. The controversy around the Social Security Act 2008 is that it does not create any new provision that was based on the Commission for the Unorganized Sector Enterprises report that came out in 2008. What it essentially does is it redirects several social welfare schemes and offers it in a basket to the unorganized sector worker. However, observers feel that this measure is unlikely to be sufficient to paper the gaps that unorganized sector workers feel because of their inability to obtain any benefits under currently existing labor standards that only addresses the needs and concerns and security of workers in the formal sector. With that, we come to an end of the module on labor standards. To summarize and reiterate some of the points that we have made in this module, we began by trying to understand why labor standards are required in a society. What kind of social security does labor standards provide to people who are employed? Why should labor standards be considered as one of the cornerstones of social policy? This is essentially because labor standards emerged out of working people's bargaining, collective bargaining with their employers as well as their governments in order to have safe working environments, in order to have a certain level of minimum wages, in order to have certain minimum guarantees in case of accidents and mishaps, in order to have various other forms of social insurance that is provided by their employers. Labor standards, along with universal minimum provisions and social assistance programs of all time, is likely to remain an important social policy concern in years to come because of the rise of a large number of workers in the informal sector in most countries of the world, but especially in India. A large informal sector actually entails having quite a large number of people living in poverty. And to reduce the poverty and to prevent people from being exposed to different types of multidimensional poverty and other forms of vulnerability, it is important to create labor standard that specifically targets informal sector worker. The other concern in this debate about labor laws is the current ongoing reforms in existing labor laws in the country. The concern is that would the existing reforms in labor legislation create better legislations and hence better protect the rights and contingencies of workers' lives, or would these reforms actually lead to facilitate the expansion of business and would only look at the concern of employers? Reducing the ability of workers to bargain, to use collective bargaining mechanism would also lead in future to the dilution of labor standards in the country for formal sector workers. Not having informal sector workers under any social security cover and dilution of labor standards for formal sector workers may lead to overall increase in poverty in society and also create social disadvantage and inequality. So social policy has to remain alert to the kind of labor laws that are emerging in society at any point in time. You are encouraged to read especially the NCUS report which came out in 2008 and which provides in great detail the existing state of labor laws and standards in India. You're also encouraged to look at recent debates on labor law reforms and the ongoing changes that are being brought about in some of the key labor laws that we have indicated in this module. Thank you very much for participating in this discussion.